Good afternoon. This is Senator Karla May from the 4th District coming to you again, once again. It's a lot going on in the Capitol, but what I want to talk about today is workforce. So, in the governor's State of the State address, he talked about workforce and how he's going to make sure that we have some workforce initiatives across the state to get people employed. So today I had a bill that I filed, and it was heard in committee this morning, and that bill is eliminating an employer's ability to use credit check as a defining characteristic for hiring. So basically, what employers have been doing is they've been using the credit check, getting potential employees to sign documents for them to pull their credit, and they have been denying individuals based on their credit. And I encourage everybody to take a look at the Fair Credit Reporting Act from the federal government because it has some restrictions in there on employees. So we need to know what are our legal rights in reference to this. An employee must notify you if it intends to check your credit and must get your written permission. The Fair Credit Reporting Act requires the notice to be clear, conspicuous, and not mixed with other language. So several states have passed laws prohibiting employer credit checks and restricting how the information can be used. I filed such a bill to restrict employers from using credit checks as hiring practices, except if you're responsible for a company's or a client's or an individual's money. Say, for instance, for example, an investor, a financial investor, a financial advisor, and those aspects. But in regular employment, we're restricting it. So before you're rejected by an employer based on credit checks, let's talk about some things that should happen. Warning, you should get a warning before rejection. If an employer might reject you based on somewhat or totally on your credit report, they must tell you before the decision is made. They have to send you pre-adverse action notice, including a copy of the report used and a summary of your rights. A lot of times this is not happening. They have to give you time to respond. The employee must wait a reasonable period, usually 3 to 5 business days before it proceeds. The goal for that is to let you explain the red flags that may be on your report or the negative information if it's correct or incorrect, or give you the opportunity to fix any mistakes with the reporting company. Because we know that sometimes people have identity theft and other things that are related to the credit reporting. And these 3 credit reporting agencies are not local. And most times when you call, you cannot get a person to explain to you how to use the website or the information that's on the website. So, everybody is not literate in the same aspect. And so I filed a bill to eliminate an employer being able to use a credit check as a decision in hiring. They should also give you a final notice because you have a right to a free copy. After it acts, the employer must follow up with a post-adverse action notice, giving the name of the credit reporting agency, its contact information, and explaining to you your rights to get a free copy of the report within 60 days. Now, this is what your legal rights are currently under the Fair Credit Reporting Action. So until my bill becomes law, I want to ensure that you know your rights in this situation. Again, this is Senator Karla May from the 4th District signing off. Look forward to talking to you next week.